Welcome back. The Information Regulator is once again attempting to stop the Department of Basic Education from publishing matric results in newspapers. Recently, the Gauteng High Court handed down a ruling stating that the publication of matric results using only examination numbers does not violate any of the country's privacy laws. For more, we are joined by Advocate Pansy Tlakula, who's the chairperson of South Africa's Information Regulator. Ms. Tlakula, thank you for your time and for joining us this afternoon. So maybe just explain to us the Information Regulator's position on why the publication of matric results using only that examination number poses a privacy risk.
Let me start by saying that we really respect the decision of the court. And secondly, that we had approached the court because we thought that the issue of the application or applicability of POPIA on the issue of publication of matric results in the newspaper would be clarified. Unfortunately, after this judgment, we are not any wiser. In fact, the issues are becoming even more complex. Therefore, we are approaching the Supreme Court of Appeal. We have applied for leave of, we have lodged an application for leave to appeal because we think that another court may come to a different conclusion. Here are the challenges that we have. The court, the High Court, held that an examination number is not a personally identifiable information. Therefore, it is not personal information, which means that POPIA does not apply to the publication of matric results. There are a number of problems or challenges with what the court has said in our view. Firstly, the court has used the phrase personally identifiable information. This phrase is not defined in POPIA. That's the first problem. The second problem is that the court defines this phrase without providing any legal authority for this definition. So the long and short of this is that publication of matric results through a examination number does not violate privacy. That's what the court says, and therefore POPIA does not apply. The court did not even, because of its conclusion, did not look at the other arguments, the main arguments that we had presented to the court regarding whether the issue of consent applies or not, whether the consent of the parents of the parents of the learners below the age of 18 or the learners who are above the age of 18 have to consent to the publication of the results. That issue did not even arise because the court simply said, look, this is not personal information, and an examination number is not personal information, therefore POPIA does not apply. This has huge implications for the execution of the mandate of the Information Regulator, because an examination number, although it is it's not completely de-identified as such, in the sense that, as we said in our papers, if you are sitting behind me, our numbers, our examination numbers are consecutive. So if I'm number one, you are number two on the newspaper, that's how the matric results are published. So you'll be able to determine my results and I'll be able to determine your results because we'll be coming from the same school. We will have sat in that order in the examination room. The results will be published in that order per school in the newspaper. So you cannot say we don't agree that an examination number is not identifiable personal information.
So in essence, Tlakula, I mean, you're saying that this has become complex simply because the court did not give a legal authority as to how then to define it. But you still stand on the fact that these exam numbers fall within the POPI Act, and this is then defined as personal information.
That's exactly the point, really. And if you look at the judgment itself, it doesn't quite address that, because it simply said this is not personally identifiable information. We don't even know where that phrase comes from, number one. Even internationally, if you look at international jurisprudence, I'm not saying that I have read the laws of each and every country internationally, but I must say that I have never come across personally identifiable information. But I think what is even more important is the fact that POPIA does not define a phrase. And even as the judge defines it, he doesn't tell us where he gets that definition from.
So, Advocate, there's what significance is there with regards to the enforcement notice and that 5 million rand infringement notice that has been issued to the DBE?
Our view is that the lodging of the application for leave to appeal actually means that the enforcement notice stands and the infringement notice stands until the court has heard the appeal. Therefore, that the DBE cannot publish the matric results in the newspaper until the appeal has been heard. Through our lawyers, we have written to the Department of Basic Education through their lawyers to inform them that we do not expect them to publish the results until such time this appeal has been heard. And I have to say to you that we are not just doing this because maybe we itching for a fight or we're belligerent. No, this is the very first case that has gone to court on the interpretation of POPIA. You must remember that POPIA is a new piece of legislation.
Right.
So it has not been tested in court. And if we leave this judgment without appealing, it then creates a precedent, which means that it will be difficult, as I said, for us to enforce POPIA. So we are not saying that we are correct, but let's test really this judgment in the Supreme Court of Appeal and hear what they're saying. And let's also, if the Supreme Court of Appeal doesn't agree with us, we are prepared to go all the way to the Constitutional Court simply because we need clarity as a country. Yeah. This being the first case on POPIA to be heard in our courts.
And you say this is on the basis of principle and a precedence will be set with this being the first case to test the POPIA, the POPI Act. But when you
Definitely.
speak to the people that are really at the helm of this, and this being the matriculants, what do you get as a sentiment from both learners and parents?
I mean, I don't think that applies, to say what do the parents and the learners think. I mean, if we're to enforce POPIA in that manner, then we'll have problems. We just have to look at whether the manner in which the results are processed or published in the newspaper infringe POPIA or not. That's really what our mandate. As to what people say, it's like the death penalty to say, some people say yes or no. No, we simply have to test whether that processing in that manner complies with the provisions of POPIA or not. Really, that's what the issue is. And also that I've heard arguments that we have done this before. Well, POPIA is new. Our powers as the Information Regulator only came into effect in July 2021, which is just 4 years ago. So it is important. We can't look at what happened in the past. In the past, there was no POPIA, and the privacy of children is very important.
Most certainly.
I think I need to stress that as well.
Yeah. Advocate, while we still have you on the line, I mean, in April, the regulator issued a guidance note that clarified that voice calls, including automated and robocalls, are indeed electronic communication with regards to the purposes of Section 69 of the very same Act. And this then means that unsolicited calls require explicit consent by law. But we keep getting these spam calls, especially at this time of the year. What's the regulator's take on the increase of what seemingly is these spam calls on residents across the country?
As I have said in the past, that there is disagreement between the information regulator and the direct marketing sector as to whether direct marketing through a telephone constitutes electronic communication or not. We have taken a clear view as the regulator that it's electronic communication.
Okay.
So we have to test this. What we have now, we have a complaint which will go before the enforcement committee. And you know how we deal with complaints. It's investigated by the division, which will be the POPIA division. It goes to the enforcement committee, and the enforcement committee looks at the investigation report and issues an enforcement report, which will then be considered by us as members.
Right.
And since we have issued a guidance note, we then are bound by what we have said in the guidance note. And that's, I think, the finding that we will make. I mean, I haven't seen the case because it has not come before us.
Okay.
But I suspect that if we find against the responsible party in this case, I have no doubt that they will go to court. And we welcome that because, once again, the courts in our country have to assist us with the interpretation of
Most
POPIA
certainly.
as far as that is concerned.